Hello, my name is Tom Davern, Senior Defense Counsel with Lynn, Scharfenberg and Hollick. I have been doing workers' compensation defense and subrogation for SFM for about 19 years now. I am going to discuss the legal consequences that your company may face when there is a motor vehicle accident related injury. The first point I want to emphasize is that all U.S. states recognize vicarious liability with regard to motor vehicle operation. This means that the vehicle owner is legally responsible for the actions of any permissible driver. In other words, if you let someone use your car, you can be sued for their negligence. Typically, this does have to be a permissible user. Vicarious liability would not apply if the car was stolen. There doesn't have to be specific permission for vicarious liability to apply. Permissible use can be found based on the history of use or past arrangements. The employer can also be held responsible for the actions of its employees while they are driving a personal vehicle if they are driving for a work purpose. I also want to point out that the individual employee operating a vehicle in the course and scope of employment for a company can be personally liable. Both the employer and the employee operating the vehicle at the time of the accident will be named in the lawsuit. Another legal principle that is consistent in most jurisdictions is the so-called grand bargain. Injured workers are not allowed to sue their employer for negligence. In exchange, entitlement to workers' compensation benefits for employees is on a no-fault basis. In other words, they get comp benefits if they are injured on the job, regardless of fault. However, in the event an injured worker sues a third party for negligence, the third party can file a direct action against the employer. This is where we see allegations of negligent training or hiring against the employer. Additionally, employees are not allowed to sue coworkers for negligence, the exception being if the injury was intentionally inflicted or if the employee or employer was engaged in gross negligence. I was involved in a workers' compensation claim where an employee who did not have a driver's license drove a customer's car into coworkers, causing catastrophic injuries. The injured workers were able to collect workers' compensation benefits. However, they could not sue their employer or coworker due to the lack of gross negligence. The injured workers pursued a claim against the vehicle owner who was not even operating the car at the time of the accident. The poor owner had simply temporarily given control of his vehicle to the employer for the purpose of getting the car serviced. The innocent car owner was sued in a multi-million-dollar lawsuit that stemmed from the negligence of the employee. There were defenses, but the vehicle owner's insurance company paid a lot of money to settle the claim, even though they had no part in the negligence. Once the claim against the vehicle owner was resolved, the vehicle owner then initiated litigation against the employer, seeking indemnification for what was paid to the injured workers in the settlement. What did the employer do wrong in the previous example? A negligent hiring claim could be made based on the fact that the employer hired a person for a job that involved driving who did not have a driver's license. A negligent training claim is raised in almost all third-party complaints, whether there's any merit to the claim or not. And I will talk more about subrogation in a minute, but in general, when there is a work injury caused by the negligence of an outside third party, the employee can collect workers' compensation benefits and sue the negligent party for damages not recoverable in the workers' compensation system, such as pain and suffering. The employer and insurer can make a subrogation claim against the third party in an attempt to recover what has been paid in compensation benefits. The party being sued can turn around and sue the employer as part of the same litigation. Again, typically, the employee can't sue the employer, but the third party being sued can sue the employer. The most common grounds are negligent hiring and negligent training claims. If there's merit to the negligent hiring or training claims, this can effectively wipe out any potential subrogation recovery. A common example is an employer who fails to discover an employee's poor driving record before hiring them to a driving position. I have seen multiple examples of employers and insurers losing out on potential significant subrogation recovery due to failing to properly train and for failing to exercise due diligence in the hiring process. The negligence scales gets tipped and it can diminish or result in no recovery whatsoever. I have seen multiple death claims over the years where there was no subrogation recovery due to the actions of the employer. It is vitally important to exercise due diligence with hiring, especially when the job involves driving. It is equally important to have a formal, documented training program, especially in safety-sensitive areas. These programs should be an ongoing training process and not a one-time event. The most important result is reducing the risk of serious injury or death. However, following these guidelines will protect the company when there is litigation. Accidents will happen regardless of the level of training. However, you and your company will be in a much better position if you have proper procedures in place. SFM will pursue subrogation when there is an outside person or company at fault for a work injury. The exact mechanics of the subrogation process do vary from state to state. However, the general principles of negligence are essentially the same across the board. When we can prove that a person or company not affiliated with the employer caused a work injury, they can be sued for negligence. Subrogation recoveries help to offset the impact of the comp claim for the employers. It can save premium dollars by limiting the extent of the claim. In some rare circumstances, SFM is able to get 100% subrogation recovery and essentially wipe the claim from the books. There is a tangible benefit to making sure you properly train and exercise discretion when making a new hire. I am sure some of you watching this have been through the litigation process to some degree. It can be a bit of a disruption to life, but here's what you can expect. You may be required to take equipment out of service. You may be obligated to preserve evidence, and I want to note there are civil penalties for failing to properly preserve evidence. You will be asked to produce documents and possibly sit for a deposition. Now, while the majority of claims settle, you may have to testify at trial and face questions about your hiring and training procedures. The injured worker will likely have to sit for a deposition and testify at trial if the claim does not settle. An employee's cooperation in pursuing a subrogation claim can be vital for a recovery. If the injured worker is not motivated, it can make the employer and insurer's subrogation pursuit difficult or sometimes impossible. Sometimes the employee may not have an interest in pursuing a lawsuit, even though there is a good chance of recovery. This can significantly hurt an employer and insurer's ability to make a subrogation recovery when you do not have a motivated key witness. Thank you very much for watching. You can find more educational workers' compensation videos at sfmic.com/webinars.